So after the murder, ATF agents actually found the weapon. They perhaps did not know at the time that it was the murder weapon, but did an undercover buy of a gun. It was a .45 caliber gun from a man named Antonio Fry. Turned out that gun was linked to the murder of Jonathan Price. I'm in studio with Brian Buckmire this afternoon. He has joined me. He's a New York City public defender. A lot of questions about the weapon. Can we link this weapon? First of all, the fact that the gun was not found on these suspects. It was found on someone else that's totally unrelated to these crimes. What kind of hole does that poke in the case?
Well, that poses a huge hole. We call it chain of custody. Usually you're doing chain of custody when it comes to officers, when they recover from a scene, how did it move from the scene to now the courtroom. With here, I think there's even a larger question, and maybe of a conspiracy, but how did it get to this other person? Where was this person? How was it used? They're going to have a hard time with DNA evidence, just because it might have been passed along a number of people. So it creates a number of hurdles for the prosecution.
Yeah, I would think so. And we've already seen there are a number of hurdles for the prosecution in this case. Let's hear now what happened when Doug Robinson was cross-examined by one of the defense attorneys.
Not Mr. Canada.
No.
And not Mr. Malazzo.
No.
Okay. This 2-month time period that you're buying guns from Mr. Fry, did this gun purchase occur towards the end, somewhere in the middle?
I can't recall. I can't recall. My guess is that since it was in September, probably toward the end. Yeah, because we went from different defendants, we had multiple CIs, so we had different files going on at different times.
Okay. And when you say trace the gun, you mean put the serial number in, see what the computer says about the origins of that gun, and follow up if it comes back stolen.
Well, no, the stolen check is based on NCIC, which is the National Crime Information Database. The ATF traces guns, and during the course of that trace, we put in all the information, and then people at our tracing center have to manually call the manufacturer, from the manufacturer down to the distributor down to who it goes to, and eventually to the gun store.
Okay.
And the gun store then says, yes, we received that gun, and this is who purchased it.
Okay, so there we go. I'm glad I asked. Your tracing is actually talking about from manufacturing down to point of sale.
Correct.
Okay, you did that.
That's right.
All right. And this is the gun right here, right?
That's correct. That's the same picture she showed me.
Right, it is.
So more questions about the murder weapon here, whether it in fact even was the murder weapon and why it was found in the hands of someone who is totally unrelated to both the robbery and the murder of Jonathan Price. Again, there's 2 defendants in this case. They each have their own attorneys. There are 2 separate juries, which makes it a bit of a complex case. But let's hear now some of the opening statement for Dewan Malazzo, who walks through all of the reasons why he says his client and Quincinio Canada didn't do this crime.
But there is genetic markers, alleles, DNA, found under Mr. Price's fingernails. DNA that excludes Dewan Malazzo. DNA that excludes Quincinio Canada. But before Detective Wolf learned the results of that DNA analysis, he had already decided who his suspects were. Facing immense pressure to solve a high-profile murder in a summer of high-profile murders, Detective Wolf and the Lexington Police Department assumed they knew who did it. And despite the fact that no eyewitness, not a frame of video, shows gold teeth or facial tattoos, they proceeded against Mr. Malazzo and Mr. Canada. They had their suspects, and once this assumption was formed, it would not be revisited.
So Brian Buckmire, New York City public defender, with me here in the studio. You're a defense attorney. How do you rate that opening from Dewan Malazzo's attorney?
All right, good, pretty highly. It sounds as if she's speaking as if the prosecution's already put out their case. I know that there were two different defense attorneys, and one opted to speak first, and I believe one opted to speak second.
Right.
You have the right to do that. It's a strategy. You have to be very sure of your case if you're going to do it afterwards. We're often taught about recency, primacy, and frequency. So if you're talking about the recency of that statement, your ability to get your story out as quickly as possible in the minds of the jury, oftentimes you want to do that first. You don't want to wait till you hear everything the prosecutor has said, because now your entire opening and your entire case and your summation is you digging yourself back out of that hole to try to get back to even, get back to not guilty. But I think that the way in which she's going about it, poking all these holes, showing the inconsistencies, showing where they're wrong, is very powerful and very strong.
Yeah, I mean, quickly, one thing we haven't revisited much yet is this issue, this point about the DNA. And the defense attorneys say the DNA under Jonathan Price's fingernails excluded both of the defendants. How much how much weight does DNA evidence, you think, play in the minds of jurors in this age where every crime show, Law and Order, documentaries, everything always comes back to DNA? How much value do you think juries place on DNA evidence?
From my experience with DNA in cases, I think they put a little bit too much stock into DNA. It is a science. And it's a science run by people, and people make mistakes.
Right, and we know there's not always certainty, and there are lots of, different likelihoods of something matching and so on and so forth. But I think that there's a perception in the public, oh, well, his DNA, her DNA was here, then that's it. Do you agree?
I would agree, yeah. But it's up to the defense attorney or the prosecutor to explain it. When you're excluded, though, there are different ways that DNA can come in. Either you're hit, it's insufficient because there's not enough DNA there, or you're excluded. As a defense attorney, when it comes back excluded, you are jumping for joy, and you are definitely toting that DNA is the best thing next to sliced bread. Well,
yet another hole in the prosecutor's case in this Marine murder trial. We're going to take a quick break. We'll be right back with much more after this.
A firearm first came in the laboratory on September 5th, 2014.
Okay.
It was received by me.
Okay.
And it was basically in and out of my custody until March of the following year.
Okay. And I'm going to show you now that we are going to work with Commonwealth Exhibit 84? Mm-hmm. Okay, 84.
What you're looking at here is a direct comparison between the first cartridge case that was submitted, item 1 in my case, and the second, one of the second cartridge cases that was submitted in the second submission was item 17, my laboratory number 17. This is a direct microscopic comparison from the markings found on one to the markings found on the other.
So there we just saw a photograph of the details on the casing from the gun used in the murder of Jonathan Price, I believe on the left, and on the right, details of a casing from another gun, the same caliber gun. And as we know, the firearms expert goes on to say he can't definitively link the bullet and shell casing to this gun, but he also can't rule it out. I mean, it's kind of hard, especially if you're not an expert, to look at those photos and say, okay, is it the same or not? They look similar. I mean, there's certainly a little bit different angles and ridges, but what can we make of this testimony and this evidence that was shown in general, Brian?
I think both sides are going to be able to pick apart what they want best from that testimony. The prosecutor is going to be able to connect the dots and say, hey, we've got A, B, and C. We might not have D, E, F, but understand we've got enough letters here to make out the alphabet. And the prosecutor is going to come up and do the exact opposite. If we're looking for the whole alphabet and you're missing these letters, these don't line up, then there's no guilt beyond a reasonable doubt.
Right.
And I think that's the strongest argument there.
Right. The defense attorneys are going to make that argument for sure. I mean, this question about the gun seems to be really a big question, right? Because prosecutors saying it was the same gun. You know, my question is, and I don't know how much of a firearms expert you are, but if the prosecution and police are saying this gun has the same serial number, does that not mean that it was definitely the same gun? You know? And how can they even determine the serial number of the gun used in the Price murder?
Well, guns have been designed to be much like fingerprints in how they operate. Whether you're talking about the serial numbers on the gun or the bullet, the pin hitting, well, it's not always a pin, but when the bullet actually ejects, it's being hit by an object inside of the gun, and that will leave an imprint as well, so you can match the imprints. You can also look at the striations of the bullet. When the bullet exits through the barrel chamber, it spins in a certain way that gives you certain markings on it. And what a defense attorney would do in this case is you would articulate each one of those things like as a fingerprint. And if all of those things don't match, or one of them's a little bit off, it'd be the same thing of saying, oh, we recovered a cell phone and it had Brian's fingerprint on it, except for these 3 or 4 slight deviations. And you'd be like, wait, if a fingerprint is supposed to be original to this one person, and there's deviations, that means it's not this person. And if you bring that analogy to a gun, you're saying, well, if there's a few deviations, that means it's not this gun. And where the prosecutor is really hanging their hat and saying, stole it here, this is the gun, use it here. If you can find one little kink in that chain, you get to kind of throw their whole story out the window.
Yeah, I mean, it seems like there's a lot for jurors certainly to understand about the science of not just DNA, as we discussed, of guns, of bullets, the striations, how all of that works. We're going to take a quick break. We'll have much more on the Marine murder trial as the Law and Crime Rewind continues. We'll be right back. Welcome back to the Law and Crime Trial Network. All afternoon, we have been talking about the Marine murder trial from this past summer. 26-year-old Marine Jonathan Price shot and killed outside a bar where he was with his young newlywed wife. 2 suspects on trial, Dewan and Malazam and Quincinio, Canada. Let's hear how prosecutors wrapped up their case, not just about the murder, but also about a gun robbery that happened 6 days before the killing.
He kind of cleared me. He turned around and he put the gun to my chest. That's what Shane saw, and that's what Shane remembered, and that's how Shane knows who it is that robbed him. So then we talked about what happened, and Jessica said, I screamed. And the other one comes with a gun and says, shut up or I'll kill you. And she screams again. And then Mitch is inside. And he says, I heard her scream at first, and I thought they were playing around until I heard the second scream and realized maybe not. And that's when he goes and picks up the gun. But at that point, these two, with guns pointed to Shane's head, force him inside, and then pull Jessica in. These two. They go inside. And once inside, they make Jessica lay down on the bed, and then they want Shane to lay on the bed. And Shane then lays on top of her. And he's watching best as he can, and trying to still look best as he can. Mitch is standing in there. And when Mitch tries to hide the gun behind him, one of them yells, gun, and then Canada approaches, takes his gun, goes through his pockets, flip the mattress, and then make Mitch lay down on the mattress. And then they start going through, or Canada starts going through the room, looking for stuff, taking wallets, taking money, taking the phone, got down to Springfield, taking stuff out of the room. And then after they've done that, Malazam says, come on, nephew, and then they leave. After they leave, Shane says they go down the right, back out through the tree line. Mitch then goes and starts trying to find the gun that didn't get taken, and then he's going out after him. So then Shane and Mitch and Jessica, they've come in here today. And they've talked and they've testified about what they saw and what they remember. And the defense talked a little bit about memory conformity, and I'll talk about that a little bit more too, and they've talked about it, and therefore the memories, kind of fill in each other. Except, when you listen to them, they've all kind of talked about 3 different things and 3 different vantage points. So it's not like they've kind of gotten together and all all their stories are exactly the same, then you might be a little suspect, but they didn't. Some said, I don't remember, that's been a while. Some said things a little differently than the others because they were all coming at it from different vantage points. I didn't remember conforming and getting together to do anything like that. So
that was a large chunk of the prosecutor's closing arguments in this case against Quincinio Canada and Juan Malazam. Brian Buckmire, what do you make about that? I mean, as many closing arguments do, it sort of takes the form of they said this, the defense is saying this, but no, here's why that doesn't hold. The defense is saying this, the last point we heard her get to, perhaps one of the biggest points, so what if they can all identify the suspects? Some couldn't remember, some have different vantage points. Is this convincing in your mind?
Her closing is not very convincing to me. I understand the points in which she's running through. I see the validity of them all. But in terms of the execution of them, and also the way that she describes them is not too persuasive for me, for two reasons. One, you have the ability, and for many the honor, of representing a victim who was a Marine. And when I hear her speaking, it sounds like she's speaking with her friends at a local bar or hanging out. There's not that passion or I think that righteousness or that vigor of, we're here because these two people are murderers. They killed a Marine, someone who wanted to serve this community and this country, and they stole that person, not just from this wife, this family, but from us as a country. I mean, you have the ability to make that argument, and here she is speaking as if it's just you and I speaking at this table.
Sure. I mean, and we know she did, try to drive that point home, certainly in the opening, and perhaps later on in the closing, I'm sure she does get to that. But yes, certainly she doesn't start on that strong emotional point. So that is an interesting argument that you make. The fact in the beginning that she said, well, the defense says, why did you call this expert? Or they didn't do this. And she says, what's the point when you have detectives with 20 years and years of experience and you have witnesses? In my mind, if I'm a juror, I'm thinking, yeah, but don't you want to cross every T, dot every I? So is that another shortcoming here, that she's just saying, well, they're criticizing us for not calling these people, but, why do that?
Yeah, in both our offices, as defense attorneys and prosecutors, the phrase is called drinking the Kool-Aid, where you believe in your story so much you sometimes don't see the other side's points. You don't have the ability to properly address them. And so exactly like you're thinking, when she's up there and she's saying, what about this and what about this, she's rehashing points that the defense attorney's already brought up, and maybe in someone's mind, like in yours, you're thinking, no, I would have liked to have heard that. I would have liked to have seen that, and this seems like it goes with the defense attorney's overall theme of there were some incompetencies and some things that weren't done right in this case, and that's why they found the wrong people.
So, do the defense attorneys sum up their case any better? Stick around, we're going to find out right after this break. Welcome back to Law&Crime's Rewind. We are just minutes away from revisiting the verdict in this Marine murder trial. The two defendants, Quincinio Canada and Juan Malazam. Now remember, they are being tried together, but they have separate defense attorneys and there are separate juries weighing their fates. Let's now listen to the defense's closing argument. Juan Malazam's attorney was up first.
He did not do the line. And that's not a big deal. He's done a lot of lineups, over 100. Sometimes he does them for his own cases. Sometimes he does them for other cases. But in this particular case, Mr. Kennedy's photo was altered. And it was altered to conform with what the victim said as far as description goes as to their attackers. The star tattoo was taken off of his face. And now we've heard explanation. But the thing is, there's plenty of people with face tattoos. You can do a six-pack with face tattoos. Surely, if the description included a face tattoo, this would not have been the outcome. But here we are. We can take a look at his form. Here is a spot for a narrative. And so if that were the case, if he was really sitting down saying, I feel really good about this one, but I think the nose looked more like this one. You put it right here, and then it's saved for posterity.
Ladies and gentlemen, Megan Price did not want to be responsible for making the wrong choice in this case. And she didn't make the wrong choice. But Detective Wolf made the wrong choice. Shane Hansford made the wrong choice. Mitchell Smith made the wrong choice. And the Commonwealth has made the entire trial about this wrong choice. He tried to support this assumption, but building on it other assumption after assumption after assumption after assumption, filling in the gaps of his investigation with speculation, with guessing, with timelines bent to meet what he wanted to find, by picking and choosing the facts of this case. Because Detective Wolf and the Commonwealth began this case with the biggest...
So the first closing argument we heard was from the attorney for Quincinio Canada, and that last one was actually the attorney for Dewan Malazam. Both of them kind of hitting hard on this points about the identification of the suspects. I mean, we had Canada's attorney up there with these two pictures referring back to the testimony of one of the victims of the hotel robbery, saying, you know, he doesn't, which one is he referring to that had a different nose, and also really showing how similar those two men in the lineup looked. And then we had Malazam's attorney saying, you know, the widow in this, the victim in this, Megan Price, she said she didn't want to make the wrong choice, so she made the right choice. Everyone else made the wrong choice. So it seems to come back, at least in those clips, to the identification of these suspects here. And I think that that is a key point here, right? I mean, there were not multiple people that could say with certainty, well, there was no one that could say with certainty that these were the men at the shooting and killing of Jonathan Price. And there were mixed opinions on whether these were the guys that held up the motel room. So, I mean, it's a huge flaw, I would think. It's something difficult for jurors to overcome. Do you agree?
Absolutely. And I think the defense attorney, especially the second one, was very smart to make the difference between a horrible thing had happened, the wife is absolutely a victim in this proceeding and what happened, but she's the good one. Like, they hold her to a higher standard. Right. And then they juxtaposed her, because no one's going to say that she's the bad one in the situation. Right. You again have the ability to juxtapose her to all the officers who made assumptions, made mistakes, made flaws, and you can paint them to be the bad guy and still be on the right side for both parties.
Yeah, I mean, there's certainly a lot for jurors to weigh as to not just the identifications, but all of the evidence or lack of evidence about the gun, and so on and so forth. So let's go to the verdicts and see how jurors decided. Remember, there are two different verdicts for Canada and Malazam. Let's go and take a listen.
Matter of Commonwealth of Kentucky versus Quincinio Canada. Case number 15 CR 00592-001. As to count 1, we the jury find the defendant, Quincinio Canada, not guilty. As to count 2, we the jury found the defendant, Quincinio Deontay Canada, guilty under instruction number 10, first-degree robbery, principal, or complicit. As to count 3, we the jury found the defendant, Quincinio Deontay Canada, guilty under instruction number 13, first-degree robbery, principal, or complicit. As to count 4, we, the jury, found the defendant, Quincinio Deontay Canada, guilty under instruction number 16, first-degree robbery, principal, or complicit. As to count 5, we, the jury, found the defendant, not guilty. As to count 6, we, the jury, find the defendant not guilty. As to count 7, we, the jury, find the defendant not guilty. As to count 1, the jury was unable to reach a unanimous verdict. As to count 2, we, the jury, find the defendant, Dewan Qadir Malazam, guilty under instruction number 10, first-degree robbery, principal, or complicitory. As to count 3, we, the jury, find the defendant, Dewan Qadir Malazam, guilty under instruction number 13, first-degree robbery, principal, or complicitory. As to count 4, we, the jury, find the defendant, Dewan Qadir Malazam, guilty under instruction number 16, first-degree robbery, principal, or complicitory. As to count 5, the jury was unable to reach a unanimous verdict. As to count 6, the jury was unable to reach a unanimous verdict. As to count 7, the jury was unable to reach a unanimous verdict. As to count 8, we, the jury, find the defendant, Dewan Qadir Malazam, guilty under instruction number 27, complicity to tampering with physical evidence.
So let's break this down. Canada's jury acquitted him on the murder charge, found him guilty of the robbery charge. Malazam's jury was hung on the murder trial. However, he was also convicted of the robbery at the Quality Inn. So, first, your reaction to this, Brian. Any surprise on the murder acquittal?
Not at all surprised. Again, as we've been discussing over this time, there's a lot of holes that lead them to believe that it is actually not them who committed the crime, and a lot of reasonable doubt there.
I mean, in terms of the robbery charge, and let's just go to that before we get to the hung jury, it's interesting because it seemed like there was also, a lot of doubt, really, in the victim's identification there. Maybe not as much as in the Marine murder trial, because you had two guys saying, okay, it was him, but then one of those guys said, well, I didn't know it was him at first, but now I think it's him. What do you think the difference was? Just that at least two of the victims said, okay, yeah, I'm pretty sure that it was him?
I think it'd be the strength of what occurred on the stand as those victims were there and as they testified to their identification. I think, again, it goes back to the concept of beyond a reasonable doubt. And we were speaking a little bit over the break that if you were to get 5 lawyers in one room and ask them to describe it, you might get 5 different definitions. And so to measure the quantum of information that you have that raises you to that beyond a reasonable doubt is different for some people. And I think it was easier for the jury to say, you know what, they were unsure, they were kind of iffy, but I understand the confusion and the complexity of that type of incident and why you might be a little off, but they were sure enough.
So Malazam's jury was hung on the murder charge, and prosecutors intend to retry him on that charge. Do you think they might have any better luck the second time around? I mean, what might they try to change up? What can we expect from another trial or retrial?
I think what you can expect is the prosecutors either attempting to condense their arguments, that being, don't overreach so much in terms of circumstantial evidence. Don't maybe marry yourself so firmly to this gun is the reason why we know it's him who did the shooting because it's him who did the robbery. But I think, for the most part, retrials go in the favor of defense attorneys because you have the testimony of every person who's going to testify. You have the ability to impeach them. You know where they're going to go. You know where the prosecutor's going. And for a defense attorney, we see the holes we already can poke.
Yeah, absolutely. Well, we will certainly be staying tuned for that retrial. Now, as for the sentences on the robbery charges, Canada got 50 years and Malazam got 60 years for the robbery. The reason those sentences were so long is because they were both persistent felony offenders. So we are going to take a quick break. When we come back, we are starting a whole new Law and Crime Rewind, the Cody Lott trial. He was charged with murdering a 13-year-old girl. Stick around. We'll be right back.